Companies Act, Section 276, Removal and Replacement of Liquidator. Section 276 of the Companies Act, 2013 provides a structured legal framework for the removal and replacement of a liquidator, whether a provisional liquidator or a company liquidator appointed by the tribunal to manage the affairs of a company under winding up proceedings. This section ensures accountability, integrity, and professional competence in the administration of corporate liquidation by empowering the tribunal to act when a liquidator is found unfit or has failed to uphold the standards expected of the role. Subsection 1. Grounds for removal of the liquidator. The National Company Law Tribunal, NCLT, is vested with the authority to remove a liquidator for reasonable cause, and the order for such removal must be supported by written reasons recorded in the tribunal's order. The law specifies clear grounds on which such removal may be based, which include the following. A. Misconduct. If the liquidator engages in unethical, improper, or unprofessional conduct while discharging his duties, he may be removed to protect the integrity of the process. B. Fraud or misfeasance. Any act of deceit, dishonesty, or breach of fiduciary responsibility by the liquidator that harms the interests of stakeholders will justify removal. C. Professional incompetence or lack of diligence. A liquidator who fails to perform his functions with adequate care, skill, or efficiency, or who does not exercise the required due diligence, may be deemed unfit to continue. D. Inability to act. If the liquidator becomes physically, mentally, or otherwise incapable of fulfilling his duties, the tribunal can remove him and appoint a substitute. E. Conflict of interest or lack of independence, where the liquidator develops any interest that conflicts with his obligations, or loses independence during his tenure, and such circumstances could compromise the impartiality of the winding-up process, removal is warranted. This subsection protects the process of liquidation from being compromised by bias, incompetence, fraud, or incapacity, and maintains public and stakeholder confidence in the tribunal-supervised winding up of companies. Subsection 2. Replacement of a deceased, resigned, or removed liquidator. In situations where the liquidator dies, voluntarily resigns, or is removed by the tribunal as per subsection 1. The tribunal may transfer the responsibilities and ongoing tasks of the liquidator to another qualified company liquidator. Such transfer must be accompanied by written reasons recorded in the tribunal's order. The aim is to ensure continuity in the winding-up process without unnecessary disruption or delay. This provision gives the tribunal flexibility to ensure that the administration of the company's liquidation is not adversely affected by changes in personnel. Subsection 3. Liability for loss or damage caused by liquidator. This subsection empowers the tribunal to hold the liquidator personally liable for any loss or damage suffered by the company as a result of fraud, misfeasance, i.e., the improper performance of a lawful act, or negligence in exercising the powers and performing the duties assigned to him under the law. If the tribunal determines that such loss or damage has occurred due to the liquidator's misconduct or failure to act diligently, it may order recovery of the financial loss from the liquidator personally, and it may also issue any additional directions as it considers just and appropriate. This provision strengthens financial accountability and discourages careless or dishonest conduct by individuals entrusted with the winding-up process. Subsection 4. Right to be heard before removal. Before passing any order to remove the liquidator under this section, the tribunal is bound to follow the principles of natural justice. The provisional liquidator or company liquidator must be given a reasonable opportunity to present his explanation or defense against the proposed action. Only after affording this opportunity can the tribunal proceed to issue a removal or replacement order. This ensures that no adverse action is taken without due process, and the liquidator has a fair chance to refute any allegations or justify his conduct. For more details, contact us.